I mentioned earlier that the compensation system has divided employers up into Schedule 1 and there's Schedule 2 to the Act. Now, we don't have time to cover the details of who's in Schedule 1 and who's in Schedule 2, but I think a rough overview will suffice. Schedule 1 to the Workplace Safety and Insurance Act lists most of the industries that you would expect to encounter in the private sector. The schedule lists the type of activity, the type of industrial activity carried on. It doesn't list the names of employers. So, for instance, it will list mining, manufacturing, construction, wholesale and retail sales, and professional services. Schedule 2 are industries which you would expect to see carried on by the public sector or entities that are heavily regulated in the public sector. So entities such as telephones, airline companies, railways, shipping companies, obviously municipal governments, and provincial government agencies. So one of the things you have to remember is that there is a difference between the right to sue between Schedule 1 and Schedule 2. Schedule 1 worker can't sue his own employer. Schedule 2 worker can't sue his own employer, but then there's a difference. A Schedule 2 worker who is injured by the fault of any other employer except their own can say, you know what, I don't want those WSIB benefits. I want to pursue a lawsuit instead. They can sue over into the Schedule 1 section. That being said, most of the files you're going to see are going to deal with your insureds who are in Schedule 1 industries. And so it may be easier to ask the question, who's not in Schedule 1? Well, the Act names a few. It says that casual workers who are employed in tasks that are not part of the employer's industry are not covered by the Act. It says that home-based peace workers are not covered by the Act. And it says that executive officers of Schedule 1 industries are not covered by the Act unless they apply for individual coverage. The regulation made under the Workplace Safety and Insurance Board Act names some others who are also excluded from coverage. The list is a bit eclectic, and I can't really tell you that there's a good system as to might explain why people are on the list. Let me give you some examples. Barbering and shoe shine establishments are excluded from coverage. Educational work, veterinary work, and dentistry are excluded from coverage. Funeral directing, taxidermy, photography. The Workplace Safety and Insurance Board has created what's called, they call an employer classification manual, and it sets out other industries which are not required to enroll with the board. Those include insurance brokers and real estate brokers, travel agencies, call centers. Those are just some examples. So to find out if there's mandatory coverage for the parties that are in your file, we can do a search of the Employer Classification Manual, which is found on the website of the Workplace Safety and Insurance Board. It's a great place to start, and it will provide a lot of information, but it's not the final answer because some of those optional employers have exercised that option and become enrolled with the WSIB. And that answer can only be found by either getting the information from the WSIB or from that employer themselves. So your own insured may be able to tell you if they have an account with the WSIB. And remember that the failure to enroll by a mandatory coverage employer does not change anything. Workers have coverage even if their employer fails to enroll with the WSIB, if they're in a mandatory enrollment industry. So look for all the information you can locate in your file. You may want to use the examination under oath to ask additional questions and to find out more about the work situation. You can ask your insured for information, the one that you're providing a defense for, and you, of course, can ask employers directly if they are not represented. And then, of course, you can do that other thing, pick up the phone and call Shawn. And I'll do my best to help you out.